All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in State v. Maroli, our cause number 1CA CV130263. Counsel, before we get started, I need to advise you that we are being videotaped in our argument today. As you're probably aware, we have read the briefs and the record and are quite familiar with the issues pending in the case, so bear that in mind as you begin your presentations. Each side will have 20 minutes for oral argument. For the appellant, you may reserve as much of your time for rebuttal as you wish, but you're responsible for watching your own clock. When the 20 minutes is up, any time for rebuttal is gone. And with that, we may begin.
Good morning, Judge Schwan, Judge Jones, Judge Brown, Thomas Baker on behalf of Appellant Maroli. I do know you have read the briefs and are well prepared. I've been before the panel before, and I don't want to reiterate here in oral arguments what we have in our briefs. We did raise 4 issues for the court. The initial one being the lack of standing of the Department of Insurance to bring a forfeiture matter pursuant to the motor vehicle statutes when there is no allegation within the petition of any type of insurance fraud. And I cited the Arizona statutes limiting the Department of Insurance and the director's responsibilities to that of Title 20, the insurance code. And there are no allegations of insurance fraud in this matter. The proper plaintiff would have been the Department of Transportation. And although Arizona does not have the federal equivalent of a statute or a case in controversy requirement, it does require a plaintiff. Arizona does require a plaintiff to establish standing as prudential and the reasons to exercise of judicial restraint. It also requires that the parties be true adversaries and that the plaintiff or parties have particularized injuries to themselves. And as we stated in the brief, not so for the Director of Insurance.
Well, the Director of Insurance appeared as a relator. Why doesn't that work? Because
under the statutes that we cited, the Title 20, there's no authority outside allegations of insurance or insurance fraud.
But didn't the Department of Insurance act as the investigative agency here?
One of them.
Okay. And then it applied to the Attorney General's office?
Yes. So it may have started out with an insurance fraud, but there was never any allegations of it.
Of what? Of fraud itself?
Yes, insurance fraud or anything to do with the Department of Insurance.
But the Attorney General ultimately filed
Yes,
the action on application by the Department of Insurance, the investigative agency. There's no argument that the Attorney General didn't have authority, is there?
No, sir.
Okay. So what should the Attorney General have done?
Gone to the Department of Transportation, the Director of Transportation, if they want to file a forfeiture action under Title 28. There are other statutes they could have brought one under, but they're one under Title 28 only. Okay. Second one is the timeliness of the petition. Under the Title 28 forfeiture statutes, the 4594 and the 4595, the time for bringing a petition is 60 days after seizure, whereas the state's general forfeiture statute is 60 days after seizure for forfeiture, those 2 extra words. There is no requirement that the items be seized for forfeiture in order to trigger the timeliness, the 60-day requirement for filing the petition.
But isn't the statutory language you're talking about 284594?
Yes.
Yeah. And doesn't that say within 60 days after seizure or such other reasonable time as is set by the court?
There was no other time set by the court.
Well, the court implicitly
Did the court have to do that expressly, or could it do it implicitly?
Well, I would think that a party that wants to extend the time would go to the court and request an extension of time. The court never implicitly, I assume, because it was never ruled on. The motions were filed early, but there was no reasoning given. He didn't say, I find this 4-year period to be a reasonable extension of time.
The court just summarily denied the motion?
Just denied the motion.
Well, what else could the court really have done, though? In this circumstance, the evidence was being held for a substantial period of time while further criminal charges were being investigated, right?
The property in this case is disassociated from any of the other criminal proceedings.
Well, as of a certain time, it became that way, but it was unclear up until well after the seizure that would be the case, right?
We don't know.
But what would you have the state do then? In the middle of criminal proceedings, take potential evidence and start distributing it? They can't do that.
No, you would go to the court and request an extension of time as permitted by the statute.
Okay. I understand.
And even after the date that they say, okay, the criminal cases are all concluded, we know now we don't need evidence, the seized property for use in any criminal proceeding, it went again beyond the 60 days. And again, a party that's coming up against a deadline is free to file a motion, as the statute says, requesting additional time. It was never done. The court never ruled on the reasonableness, simply denied the motions to dismiss. I want to skip to the issue 4 because I think it needs discussion. That's what really happened in these proceedings. Under the MVD statutes, the 28, 4594, and 4595, the court was limited to making a ruling on whether the items were contraband or non-contraband. The state files its petition, sends out the notices to potential claimants. The only claimant that stepped forward was Mr. Moreau. There was one other individual on one vehicle, but he withdrew his claim. So it's just Mr. Moreau in the hearing, the evidentiary hearing, on the issue of contraband versus non-contraband. If the VIN numbers or identification numbers cannot be temporarily or permanently restored, in other words, to determine their actual identity so that an actual owner can be identified, then the court makes a ruling on whether it's contraband or non-contraband. The court, in its minute entry, final judgment, found some items non-contraband, other items contraband. We now know the state has taken the position, even though their trial position was contraband, meaning no one can possess it, to, well, we want to actually return or give these contraband items to third parties who didn't appear in the proceedings. And we've never had a hearing on superior property rights. Under the statute, the court was limited to contraband versus non-contraband. If it's contraband, no one can possess them. It's contraband. If the state says, well, we're willing now to give the state identification numbers to these items and give them away to third parties whom we, the state, has decided is the true owner, even though their position was the true owner could not be determined at the time of the hearing because the numbers couldn't be restored. That's doing so without providing us an opportunity to contest our ownership or possessory interest superior to whomever they want to release the property to.
Well, it sounds like you're envisioning maybe a different proceeding than was at issue. This was a forfeiture proceeding.
Is a forfeiture contraband,
so the question
non-contraband?
is, does the property get forfeited to the state?
As contraband.
As contraband.
And the judge said it's contraband. No one can possess it but the state. But then the state says, well, Judge, we want an order saying we can give it away to these people. We're saying, well, wait a minute. They didn't appear in the hearings. They didn't file a claim.
But I guess the question, going back to the question of standing, what's your client's standing to raise that argument? If your client's standing is to raise the argument of possessory rights, once the property is forfeited to the state.
It's the state's property.
But it was forfeited as contraband. No one can possess it. Then they
Well, the
switched
state
horses.
can possess it. That's what forfeiture is.
Correct. But what they're saying is we want to give it away to these people.
But again, what's the standing? Whether the state gives it away to the people it thinks are the rightful owners, melts it down, sells it. Once the title is transferred to the state, what standing does your client have to raise that issue?
If the state wants to melt it down as contraband, we have no standing. If the state wants to take it from us and give it to him under the guise of contraband, then we're entitled to a due process hearing to adjudicate our property rights are superior to whom they want to give it away. The problem is they want to...
At that point, it isn't the property rights of someone in the next couple of steps they want to give it to. In that hearing, it's that the title to that property is going to be taken by the state, so it's you against the state. Once that's decided, then it's whatever the state decides to do with it. How do you have standing then to object that they didn't melt it down, that they sold it in a state auction?
You can't. It's contraband. The court ruled it's contraband.
Well, once it's forfeited, though, and the state acquires ownership, it's not contraband. There's no law that I'm aware of that says that the state has to take all forfeited items of contraband and destroy them. The state can auction them. It does all the time.
There's no ruling in the regular general forfeiture case under the racketeering or under the Title 13 4300s that the item is contraband. The rulings are it was used to facilitate criminal activity, it was proceeds of criminal activity. Those are the findings in the forfeiture case, not
then
contraband.
let's use the word contraband carefully. Cocaine can be contraband, and nobody can possess it.
Correct.
An auto part is not inherently contraband. It may be the fruits of criminal activity.
Correct.
But it is not inherently incapable of being possessed.
Correct.
So, again, once the question is, does your client have a right superior to the state under the forfeiture statute? Right? Once that question is answered in the negative, whatever the state does with it is
well, what the state
State's
did was obtain an order, and I agree completely that if the forfeiture action were brought saying these vehicles were proceeds of criminal activity, used to facilitate criminal activity, were stolen property, that doesn't mean that they're contraband. It means they can be put back into the stream of commerce, sold by the state, sold by the police department, what have you. But when the court makes a determination this is contraband, equating it to cocaine, you can't give it away to third parties. And if you can, it's got to go to the claimant.
But I think we're getting hung up on the word contraband. What the Superior Court actually said was that the state had a burden of establishing probable cause for forfeiture.
Mm-hmm.
It doesn't necessarily mean, that's not synonymous with contraband.
Well, the contraband is used in the statute.
Yes.
Do you have any authority for the notion that forfeited property forfeited to the state must be destroyed, as opposed to the state thereafter auctioning it, selling it, utilizing it by drug teams that are taking cars that have been forfeited and using them in drug interdiction?
It depends on the reason for forfeiture. If it's seized as proceeds, facilitation, stolen property, no. It can be sold. I agree with that completely. But when you declare an item to be contraband, meaning the numbers cannot be temporarily or permanently restored, the owner cannot be identified, public policy on dealing with, apparently it's public policy on dealing with such items is they cannot be put back into the stream of commerce.
Okay, so if you've got a part that cannot be identified, you're saying the state lacks the authority to auction it off?
Yes, because the judge has declared it to be contraband.
And there again, do you have a case to give me on that so I can go look at that?
There is no case law on these statutes.
You're taking a hard and fast position. It cannot happen. And your position as to why it cannot happen is based in your assertion that it can't happen?
It's based on the assertion that the court ruled, and the testimony at trial was, that identification numbers cannot be temporarily or permanently restored. Therefore, it's contraband. Now, the state has taken the position that despite its status as contraband, meaning no one can possess it,
Well, who says meaning no one can possess it?
that's the definition of contraband.
Where?
I didn't quote the definition
But-
and get
but-
out of Black's law. Contraband's contraband, like commonly drugs. As
But
you,
there's nothing, but these aren't drugs. And so what you're saying is that by eradicating the identification number on a vehicle, that vehicle becomes radioactive and must be destroyed. It can't be used for any purpose.
It can be for law enforcement only, or destroyed. It can't be put back into the stream of commerce. If it can be put back into the stream of commerce, then it has to go to the claimants who appeared. If it's just going to go to random third parties whom they choose,
Okay,
not sold at auction, but just, you want it? Oh, we think you own it. Here you go.
What if a vehicle catches on fire and the VIN burns up, but there are a lot of good, valuable parts there? Can they not be sold?
Yes, because the hearing was on not only vehicles, but major component parts. So in your example, car catches on fire and burns. If the transmission, the driveline, the axles, the doors, all those parts, if they're individually numbered, if those numbers can be temporarily or permanently restored and identified, they're taken off the vehicle. The statute allows the person to take those off the vehicle.
What about the body of the car?
If it cannot be permanently or temporarily restored and identified, it's contraband.
Okay. And is there anything apart from Black's Law Dictionary in the language of the statute that you feel evinces a legislative intent toward that sort of black and white result?
To take it out of the stream of commerce,
Forever, yeah.
just that it's declared contraband. And our biggest issue there is to have it declared contraband and then turn around and give it to someone who is claiming superior property interest, and we don't have an opportunity to contest. If it's contraband that can go back into the stream of commerce, that the state sees from my client, before the state does that, we're entitled to litigate the competing property rights between that person and my client.
If it's contraband, then is your client here arguing for the public good that it can't enter the stream of commerce because it's somehow contraband, or is your client arguing that he can own it? Because if it's contraband...
We're saying if it's contraband, treat it as contraband. Don't do an end run around the statute by giving it away to people that claim it's theirs, that did not participate in the hearings by filing a claim.
If it's contraband and he can't own it,
No one can.
then he's appearing sort of as a private attorney general protecting the public from
No,
that
well,
stream of commerce?
We're saying it's wrong to take property from my client, declare contraband, and say he's the only one who cannot possess it now, and that's in the statute. It's contraband only to him.
Counsel, I want to hear, you're running out of time, but I want to hear one more argument, your burden of proof issue, if we may.
Sure.
Can you give us your argument that there was an improper shifting of the burden of proof in this case?
Sure. Under the statute, it says state has to make the initial burden of proof of probable cause, just like under the regular forfeiture statute. Then the claimants bear the burden of proof to prove that the items, serial numbers can be temporarily or permanently restored. Unfortunately, as we filed a motion and was denied, client doesn't have access to the confidential VIN numbers, which would be used. Doesn't have access to the law enforcement database to show if the vehicle had ever been reported stolen. Doesn't have a way of meeting his burden of proof. That is done by law enforcement that examine the vehicles. And what the court said, and we filed a motion wanting the information on the confidential VIN numbers, the location, the numbers, the photographs they took. The judge said, we're not entitled to them unless the state uses it in their case in chief. If the state wants to rely on it, then they have to provide it to us. If they don't use it, we don't get it. So if we don't
is
get
that a
it,
burden of proof issue, or is that an evidentiary issue, a disclosure and discovery issue?
well, the burden of proof in the statute is that the claimant has to prove by a preponderance of the evidence that the original identification numbers can be permanently restored to the item or that the item can be rendered non-contraband.
So I guess we're back to my question. Is that a burden of proof issue,
Yes.
or is that a discovery failing of some sort, a disclosure failing?
That's a burden of proof. And when we tried to get the discovery on that burden of proof, we were denied unless the state was going to use it in their case in chief.
Okay.
Thank you.
All right, thank you.
Good morning, Your Honors, and may it please the Court. Lynette Evans, Assistant Attorney General for the State of Arizona. Your Honors, this is an unusual forfeiture case, a Title 28 forfeiture case. And those statutes, the statutes found in Title 28, should serve as our roadmap for this case. Now, appellant has raised several issues in his brief, and almost all of these issues can be addressed by the clear legislative intent and plain language of ARS Section 28-4594 and 4595. Appellant has raised four issues that he mentioned: his standing, timeliness, burden of proof, and disposition of contraband. And again, all these issues, except for the constitutionality of the burden of proof, are directly addressed by the statute. And first, in regards to the standing, the statute makes it clear. If you look at ARS Section 28-4594, it requires that a law enforcement agency immediately seize and store contraband vehicles and major component parts. The statute defines contraband as a motor vehicle or major component part of the vehicle that has had the manufacturer's or department's serial or identification number removed, defaced, altered, or destroyed. The statute also includes a forfeiture process, which requires that either the county attorney or the attorney general's office file the petition for forfeiture in Superior Court. And that's exactly what happened here. Just by way of background, the Department of Insurance, several responsibilities. One of those is the investigation of insurance fraud. And in order to carry out that duty, the legislature granted the department investigators law enforcement authority under ARS Section 20-466. Now, this case originated out of a fraud investigation by the Department of Insurance. And specifically, the property at issue in this petition was recovered during the department's criminal investigation of appellant's suspected insurance fraud. Now, in exercising its investigatory powers concerning that suspected fraud, the department was acting as a law enforcement agency, which is consistent, again, with ARS 20-466.
Is there anything in the statutes, counsel, that requires the Department of Insurance to pass off responsibility for the processing of the forfeiture, or the bringing of the forfeiture action to the Department of Transportation, since they're vehicles?
I'm not aware of any requirement in the statute, Your Honor. In fact, in the Title 28 statute just talks about a law enforcement agency and then working with the county attorney or the attorney general's office in order to proceed with that forfeiture action. There's no specific reference that it has to be brought by the Department of Transportation.
When my question would be that contraband material subject to forfeiture certainly exist outside the realm of those things that are handled by the Department of Transportation, correct?
Yes, Your Honor. Certainly this is not...
It's not just cars and trucks.
Correct.
Or automobile parts.
Correct.
So the Department of Insurance, based on potential insurance fraud and their fraud investigation unit, has the right to bring. The Department of Transportation has a right to bring. What decides who takes?
You know, there's nothing in the statute that determines that there's a specific agency that has the primary responsibility or duty or ability to bring this type of action. Again, the statute's pretty broad. It talks about a law enforcement agency. And so, again, the process seems to be that a law enforcement agency can work with the county attorney or the Attorney General's office to say, all right, we have vehicles or parts of vehicles that we identified as contraband. We need to proceed with a forfeiture action in order to handle those specific vehicles.
Would it make any sense if you found where someone was stealing computers and computer parts that could be rendered, I don't know if this is possible, rendered generic, I guess is what I was going to say, by the removal of numbers or something like that? Would it be appropriate to transfer those over to the Department of Transportation for forfeiture?
Certainly, it wouldn't fit with the Department of Transportation's general mandate. So, and because the statute, the specific statute, only deals with vehicle and vehicle parts, obviously that type of scenario wouldn't fit with this particular statute.
But it would fit with Department of Insurance. I
would agree it would fit with the Department of Insurance and their general law enforcement authority if it was related to an insurance fraud investigation.
Thank you.
So again, the department followed the process that's laid out by the statute, and this was very consistent. They were acting as an authorized law enforcement agency. So therefore, the state does have standing to bring this petition for forfeiture on behalf of the Department of Insurance. In regards to timeliness, which is the second issue raised by appellant, again, it's clear when you look at the statute that the petition was filed within a reasonable time. Now, appellant moved to dismiss the petition at the trial court because of his argument about it being untimely. And I just want to remind the court that generally the Court of Appeals applies an abuse of discretion standard to motions to dismiss and questions of timeliness. So now when we look at the statute, it does set a 60-day time frame for filing a petition, but it also allows the court discretion.
Did the state ask the court to exercise the discretion? And did the state file a motion for extension of time?
Right. The state it didn't have to file a motion because the appellant in this particular case actually filed a motion to dismiss very early on in the proceedings and said, this is untimely, Your Honor, you should dismiss the case. As a result, in response, the state had to put forward its arguments as to why the petition was filed when it was, and that motion to dismiss was denied by the court. So it was effectively dealt with. It was implicitly, if not directly addressed by the court, the timeliness of the petition. And what appellant is asking for today is for this court to completely ignore the rest of the statute, which says that the trial court has discretion to consider those petitions filed after the 60 days. It says it may set some other reasonable time. Now, in this case, the property was held as evidence until the decision was made as to whether or not further criminal action would be brought against Mr. Morrell. And when that decision was made, that's when that 60 days began to move forward. Now, Judge Warner in this case considered all of the legal arguments and all of the facts and determined that the state did file the petition within a reasonable time. For this court to conclude otherwise would require an abuse of discretion determination. And appellant fails to provide any argument, any case law, or any facts to support that conclusion. It's a very high burden to get to abuse of discretion, and nothing in this record justifies that determination. Appellant here just disagrees basically with what the trial court's decision was, and that's not a basis for overruling that decision. Now, Judge Warner determined that the timing of the petition was reasonable, and this court should affirm that decision. Also, if you look at it just from a purely legal perspective, this court has said in other cases that if a statute states a time for performance of an official duty without any language that denies performance after a specified time, that statute's considered directory, not mandatory. So, as appellant correctly pointed out in his brief, the Title 13 forfeiture statute, it actually contains a very specific remedy for petitions that are not filed within 60 days. If the property has to be released, if there's a request by the claimant, and it's released pending further proceedings. Title 28 statute, it does not contain any language like that, which again supports this argument that the Title 28 statute would be directory, not mandatory, in regards to those 60 days. Now, the burden of proof is another argument, obviously, that's been raised by appellant. This court should decline to even consider that argument because the appellant has waived it. He didn't develop it, and he failed to provide authority to support that argument. He didn't challenge the constitutionality of the burden of proof in the trial court. So this issue was not raised to Judge Warner. It wasn't an argument that was considered. And this court generally will not consider arguments, even constitutional ones, raised for the first time on appeal. Now, in addition, the arguments in the briefs, they lack case law or legal authority. If you look at the Arizona Rule of Civil Appellate Procedures, specifically subsections 13A6 and 13B1, they require that appellant provide the reasons for his contentions along with citations to authorities. And even if this court were to put that aside and would want to consider this argument, it still fails as a matter of law. Appellant's basic argument is that the statute improperly shifts the burden of proof. And it's certainly true that the Title 28 forfeiture statute is slightly different than the Title 13 in regards to the procedures. But that by itself, that doesn't make it improper or certainly not unconstitutional. In fact, we have case law about the constitutionality of this burden of proof. The Title 28 burden of proof, the process is the initial showing is the state has to show by probable cause that the items are in fact contraband. And it's at that stage that the burden then shifts to the claimant to show by preponderance of the evidence that they are not.
Well, if
Now,
this matter were simply to proceed to trial, the initial burden would be on the state to show that the matters were contraband.
that's correct.
How would that? How does that differ here? I guess is my point.
Yeah, there's a slightly different procedure. There's like a notice of pending forfeiture. The process is a little bit different.
Notice is different.
Correct.
But again, it's still, the burden still remains principally on the state to categorize and catalog and list the reasoning behind why each of those items is deemed contraband, and that goes forward then to trial, correct?
I would agree with that, Your Honor. And it's also similar to the burden of proof that existed in a previous version of the federal forfeiture law, which is the law that the various federal courts, the courts of appeals, and various circuits looked at when answering that question about whether or not that burden and that process was in fact constitutional.
So I guess I would say then a fortiori it follows that once the state has met its burden and presented the contraband, the proposed, the anticipated contraband for consideration by the court, then it would be the defendant's responsibility to come forward and argue why in fact it was not contraband or did not deserve to be on that list.
That is correct, Your Honor. And it's interesting because the cases that looked at that burden also talked about, and at that stage then the state would really have to come back with evidence to kind of also meet that preponderance statute. So I think that was some of the underlying analysis as to why they weren't concerned about this constitutionality question with this burden. So based on those decisions, there's nothing improper or unconstitutional about the burden of proof that's outlined in Title 28. The final argument raised by appellant concerns the disposition of the contraband. And for that question and that answer, we can again return to the roadmap of Title 28, Section 4594 and 4595. The statutes give very clear authority to the state to dispose of forfeited property. Now, it makes it clear that after an item is deemed contraband, the state can dispose of the property as it deems appropriate, and that's the exact language in 28-4595 subsection C.
Would you view that as being completely discretionary? Any limit to that level of discretion?
No. I think there is some limits. Deems appropriate. So certainly consistent with the law and consistent with existing practices. I mean, it certainly would have to be, again, appropriate under all of those types of circumstances.
Couldn't just give it to its own employees.
That, to me, would probably fall on the end of not appropriate. Now, appellant argues that the state cannot return the vehicles to their original owners, but I want to point out to the court, well, and also he's asking, obviously, that somehow it be returned to him or there be a process where he can assert his claim. But that's certainly a violation if you look at the statute. It specifically says that an item defined as contraband should not be returned to a claimant, which would be appellant in this case under any circumstance. Now,
But counsel, the people who actually received these items of contraband, where the ID numbers could not be replaced, identified, what were they supposed? Are they not still holding contraband?
They wouldn't be at that point, Your Honor. Basically, there is a process laid out in another Title 28 statute that allows for a special identification number to be
issued by the department.
So there's a process so that items that were contraband, right, that we're concerned about the identification of them and concerned about the documentation, there can be a process to identify, to document, so that they can be put back into the stream of commerce. And it's interesting because there's actually another section of the statute that's not directly at issue here, but it's 28-4594 subsection 2A. This is a provision that was specifically created for vehicles with VIN numbers or identification numbers that can be permanently restored. So a slightly different case here, but it's important to note those vehicles, they're still considered contraband, right? Their identification numbers are still altered, defaced, removed, or destroyed. But the statute actually allows law enforcement to return those items directly to the owners. The agency itself in the statute makes that determination. There's not a court hearing that's required. There's no further proceedings. They can actually give that directly to those owners. It's still contraband. Now, in this case, again, the norms were temporarily restored. So
Is it still contraband once it's in the hands of the owners?
I would say not, and especially once it's gone through that other Title 28 process of being identified.
There's nothing that specifically says that. I mean, it's a logical interpretation, I'll grant you, but there's nothing that says upon return it's no longer contraband.
No, what the definition of contraband is when that number has been altered, defaced, destroyed, or removed. Once we've taken that back and gone through this Title 28 process, it's no longer altered, defaced, removed, or destroyed. Okay. So there, again, there's a process to do that. Now, again, in this case, we didn't fall under that provision, so we filed under temporary. But getting that underlying concept, right, of returning vehicles to their owners certainly would extend to this type of situation, and it would be very consistent with the broad authority that's granted to the law enforcement agency in these circumstances. The statute grants the broad authority to dispose of contraband, and that includes returning vehicles to identified owners. The only thing expressly prohibited by the statute is the returning the contraband to appellant in this circumstance. There's one remaining issue that I just didn't address in my brief that I wanted to touch on quickly. Appellant has requested that the court award attorney's fees under ARS Section 12-348. I just wanted to point out to the court that in subsection H2 of that statute, attorney's fees do not apply to proceedings brought by the state under Title 13 or Title 28, so it wouldn't apply in this case. But in closing, Your Honor, I just want to remind the court of a few obvious but very important points. First, Judge Warner carefully considered the legal arguments presented in this case. He presided over a 5-day bench trial during which he heard all of the evidence and all the testimony presented by both sides. Appellant had a full opportunity to present his arguments and his case, and after careful consideration, Judge Warner issued a detailed ruling in which he addressed each vehicle and part and determined whether they were contraband or not. Now, adopting appellant's argument would unjustifiably undo all of that work. Now, oftentimes statutes are unclear and they don't directly address the questions we have, and in those instances, it's incumbent upon the court to search for the meaning, to find the intent, or to explain the process, but that is just not the case here. All but one question that appellant has raised, all but one, can be directly addressed by the plain language of the statute itself. The remaining question, that constitutionality of the burden of proof, has been squarely addressed by federal circuit courts who have looked at this issue. So for those remaining issues, standing, timeliness, and disposition of property, Title 28 provides a roadmap, a very clear roadmap, and Judge Warner correctly followed that map, and this court should also. Thank you.
Thank you. We have a few seconds left.
Thank you. Under 284594, it says the state can do three things. If the numbers can be permanently restored, they do one thing. If the numbers can be temporarily restored, they do another. If they cannot be permanently or temporarily restored, then they have 60 days to file the petition to declare contraband. They went under the statute. They cannot be temporarily or permanently restored, meaning that the last owner or the official records cannot be found. It's contraband. They can't say, okay, now, miraculously, we believe he's the last owner, even though our entire position is under that section, cannot be identified. We're going to give it to him.
All right, thank you.
Thank you, Judge.
All right, thanks to both counsel for their arguments. This matter is now under advisement, and we will issue a written decision in due course. At this point, we will stand in recess and allow the next case to set up.